Hi, everybody. As promised, I'm gonna record a very short video just to kind of conclude and maybe clarify a little bit better some of the last points that we covered on our last class on international trade law and WTO law. We were discussing subsidies and the subsidies agreement, and I showed you this slide where you can see the disciplines that apply to subsidies. So once you have a subsidy within the definition of the subsidies agreement, Article 1 that we saw together, and that subsidy is specific, then the disciplines apply. And the disciplines are of two kinds. Subsidies are either prohibited or actionable. I mentioned that there used to be a third category, non-actionable subsidies. It was a carve out for certain research and development, certain regional subsidies, and certain environmental subsidies that were somehow excluded from the disciplines. They were actually very limited. But this provision, which used to be Article 8 of the Agreement on Subsidies, expired in 2000. And WTO members couldn't agree on renewing the provision. So what used to be Article 8 of the subsidies agreement on non-actionable subsidies is no longer in force. So whenever you have a specific subsidy, it can be prohibited or actionable. And we saw prohibited, and I was showing you Article 3, that's where you find the two types of prohibited subsidies. We talked a little bit about them already, so I'm not going to spend too much time now. So it's those subsidies that are contingent on export and those that are contingent on the use of domestic or imported goods. And for this second type, I also told you that we call them local content requirement subsidies. You might hear this other term, and I used the example of that subsidy introduced in Canada, in the province of Ontario, for electricity producers, where these producers could qualify for the subsidy if they sourced electricity from renewable sources, but also if they used a certain percentage, which was quite high, of locally sourced inputs, equipment, machinery. And again, the problem was for European Union and Japan that they used to export these inputs to Canada. But now Canadian electricity producers, they prefer to buy locally and to use local inputs to be able to qualify for the subsidy, and that has an impact on exports from, in this case, the EU and Japan. And that's why, in this specific instance, they brought a dispute against Canada. So these two types of subsidies are considered especially trade restrictive. And you need to keep in mind something that I mentioned at the very beginning, which is that the whole point of this agreement is to, in particular, regulate those subsidies that restrict trade. So if a subsidy has no impact on trade, then it should be in theory okay. So these two types are considered especially harmful for international trade, and that's why they are prohibited. Now, otherwise, all other subsidies that are not prohibited, they can be actionable. They can be actionable, which means, as we will see, that members that are affected by these subsidies can take certain actions against these subsidies. Somebody asked me actually, and so I will clarify. There are three types, of adverse effects, let's say, that can be taken into account when looking at actionable subsidies. So those are those subsidies that create either an injury to the domestic industry of another member, or nullification or impairment of benefits of other members, or serious prejudice to the interests of another member. So they are, slightly different situations. The first letter A, refers to a material injury, or even just a threat to a material injury. What's important here is that the material injury has to be to the domestic industry of another member that is producing like products. Here, unlike the rest of WTO law, we have a definition of what like products mean in this specific instance, and it actually refers to identical products or products that have characteristics that are closely resembling those of the products that are allegedly subsidized. So this is the case of material injury. Nullification or impairment of benefits, this refers in particular of those benefits that derive from tariff concessions. So you can imagine through tariff concessions, for example, you can have easily, access to the market of another member. But if their member subsidizes some of its own industries, those benefits that come from low tariffs can be nullified or impaired, because at the end of the day, you might still not be able to compete because those domestic industries are subsidized. And then serious prejudice to the interests of another member. Here there are, a few different specific situations that fall under this definition of serious prejudice. For example, when a subsidy displaces or impedes concretely the import of, again, of a like product of another member. And here the definition of a like product is the same. Other situations is when you have situations of what we call price suppression or price depression. Don't it's just important that you remember that in general, these three letters, ABC, refers to a quite broad set of instances where there is an adverse effect to the industry of another country because of the subsidies imposed by WTO member. Now, this is a quite important slide that we stopped. We stopped at this slide last week, and the main point that I want to convey is that whenever there is a subsidy and the subsidy is specific, another member has two options. You can go the multilateral route, and I talked a little bit about this in class, which means that you can bring a dispute, challenging the subsidy as a prohibited subsidy or as an actionable subsidy. For example, in that case that I was mentioning with Canada, in that case, the EU and Japan, they felt that the subsidy was an Article 3, so a prohibited subsidy. So they decided to go the multilateral route. They brought a dispute against Canada for the adoption of this subsidy. You could do the same also if you feel like there is a subsidy which is not prohibited probably, but which has adverse effects on your domestic industry. You can also challenge as an actionable subsidy under, the dispute settlement mechanism of the WTO. And then here you have if the panel finds that indeed, for example, the subsidy is a prohibited subsidy, then the country that has the subsidy has to withdraw the subsidy within a certain period of time. If that doesn't happen within that period of time, then the other country can impose a countermeasure. In case of an actionable subsidy, you see here, if the panel finds that the subsidy is indeed actionable and is in violation of the ASCM agreement, then the country that imposes the subsidy has two options. And this is because the subsidy is not prohibited per se. So the first option is it can remove the negative effects. So you can, redesign your subsidy or implement it in a way that stops having adverse effects on the complaining country, or you can withdraw. So the choice is for the country. And then once again, you have a certain time period to do that. And if that doesn't happen, then the other country can be allowed to impose countermeasures. So that's your multilateral route. Now, given the crisis of the dispute settlement system at the WTO, this is also a long process. It might take a long time, especially in the case of, if you're having actual adverse effects. It might take a long time before something can happen and you can, start benefiting from the situation. You might want to go the unilateral track. And that's actually something that we see more and more often. So a lot of countries, when they see that another member is subsidizing, they decide to go the unilateral way, which basically means here we lose the distinction prohibited or actionable subsidy. It becomes irrelevant. Whenever there is a subsidy and that subsidy is specific, the unilateral track is basically the route to try and impose a CVD, which is a countervailing duty, which is a duty that has as a purpose to counteract the negative effects of the subsidy. You need to conduct an investigation. You need to prove that there is indeed a subsidy, that the subsidy is causing an injury to your industry, and there is a causation link, so that the injury is caused by the subsidized imports. And in that case, you can then impose a countervailing duty. There are a few rules in terms of how these countervailing duties can be imposed, in particular regarding the amount, which has to be the amount of the subsidy. It can be in place for as long as the injury remains, and in any event, no longer than 5 years. So it's supposed to be, anyway, some kind of a temporary measure. I mentioned, I think, towards the end of the class that this is, again, it's quite popular these days, and you have a lot of disputes, and we might talk about this with a lawyer from legal affairs. For those of you who are going to come to the visit at the WTO, a lot of the disputes are disputes where a country subsidizes, the other country imposes a countervailing duty, and then the first country doesn't agree with whether the countervailing, the fact that the countervailing duty was introduced in the first place, or the amount, or something else regarding that countervailing duty, and brings a dispute challenging the countervailing duty. So basically claiming that the duty was imposed in violation of the rules of the ASEM as to how you can impose these countervailing duties. And this is part of the broader trade remedies disputes. Trade remedies, when you hear this term, it includes countervailing duties, it includes anti-dumping duties, which we'll see in a second, and safeguard measures as well. So I think that the big bulk of disputes today at the WTO are really trade remedies case. So cases, disputes against countries that have imposed, countervailing duties or anti-dumping duties or safeguard measures. Very quickly, I want to tell you a few things about dumping. Now, dumping is not prohibited per se, is not actually regulated under WTO law, and this is because, well, let's start with what dumping is. You have the definition of dumping here at Article 2 of the agreement, of the anti-dumping agreement, and in general, dumping can be defined as, bringing a product into the market of another country at a price that is less than what we can say the normal value of that product. This is what is considered dumping. Now, usually the prices are not determined by governments. How much a company is going to sell a certain product. That's for the company to decide. It's for private companies. Private companies set prices. That is why the anti-dumping agreement or the GATT, WTO law in general, does not regulate dumping per se, because that's a practice of companies. And WTO law only regulates actions of states. So what it regulates and what it governs is the actions that a WTO member can take in response to dumping. So you feel that certain products are being dumped into your industry, into your territory, you can adopt certain measures, which we call anti-dumping duties, to counteract the effect of that dumping. And how you can do this, that is what's regulated with the anti-dumping agreement and also in the GATT. In particular, another important provision is Article 6 of the GATT, which, as you see, deals with anti-dumping duties. Countervailing, it's also a few rules on the countervailing duties, offsetting subsidies, and anti-dumping. And actually, the procedures and the rules for anti-dumping duties and countervailing duties are very similar. Here again, you need to prove that there has been dumping, that there has been, you have it here, voila, that there has been dumping, that there has been a material injury to your industry, and that there is a causation. So it's that dumping that is causing the material injury. And actually, the interpretation and the case law here on material injury is the same as the one that we saw as the first type of adverse effect in case of an actionable subsidy. It's the same interpretation. So once, if your investigation shows that this is happening, then you can impose an anti-dumping duty. Again, very similar to countervailing duties against subsidies. The amount has to be the dumping margin, so the difference between the price of the dumped product and the normal value of the product. And it has to be, temporary, so as long as the material injury persists, and in any event, no longer than 5 years. So this is just, some kind of general rules. And these are quite interesting, for those of you that are might at some point think to go into this area. I think it's really important to know that this is where we have really the majority of cases now, our trade remedies cases. So mostly, again, countries complaining that the way in which another member is introducing anti-dumping duties or countervailing duties is not in line with the provisions of the GATT or of the specific ASCM or anti-dumping agreement that apply. I'm going to stop here. And if you have any questions, we covered a lot of ground in these 4 sessions talking about WTO law. So feel free to write me an email about it or to come see me, during class or in my office. And then we will start next week with international investment law. I'll see you next week.